I am here. I can't see anything yet.
Planet Fitness.
Wow.
We're all...
Hey, you be quiet. I didn't tell you could do that. I'm getting chat popped out. You can hear what I'm doing. Are we starting over, ladies and gentlemen? Are we just backing up to the very beginning again? Is that what we're doing? I mean, we're a whopping 4 minutes and 30 seconds into this. Do we just back up and start from the beginning? I apologize, ladies and gentlemen. Those of you who are tuning in wondering what the heck this crazy wolf is talking about right now, we were live just a moment ago, and everything crashed out. It completely crashed on me. And I'm trying to currently get everything back online. So we'll, it is, nope. Back up. We'll do that. We'll do that. And, let's see. We'll do this. Nope. Wrong. There we will do that. We'll do that. And I'll do this and I'll say, hello, everybody. Hello. And I'll say bye-bye. And, we're almost there. Wow. What a horrible. So I believe Mama Wolfie probably filled you in on the situation. We spent half the day without power today. And, yeah, I guess these are technical difficulties kicking me in the side due to, situations surrounding that. Is everybody who's interested in watching court here? I'm not going to bother with the intro. We're going to just start from the beginning. Is everybody ready? Do we want to start with the intro? Why not? Let's start with the intro. Let's buckle back up, ladies. Let's act like it's just now starting from the beginning for the first time. We'll pretend that none of this ever happened. No tunes. I wasn't that prepared, Speed Racer. I apologize. I should have tunes in the background. You're right for calling me out for that. Ladies and gentlemen, I now present to you the program which was already in progress, got interrupted by internet dying at the most inopportune time, and we now begin again and again and again. It is April 20th, 2026, and this is the Court Gallery. Something smells fishy in court today, and it's not just the details of the DIY weed farm where the stakes have never been higher for a homesteading couple. We'll see a lawyer presenting a defense so wild Judge Simpson can't believe his ears. Was a victim really a cooperative partner in her own stalking? We'll see how Judge McNally, Judge Simpson, and Judge Mogen handle these everyday court situations, from tenants facing evictions to defendants claiming Taco Bell for their mistakes. Buckle up, ladies and gentlemen. It's a crazy day of court, and it all starts right now.
Deerfield Estates versus Emilio Castillo.
Jarrett Levine for the plaintiff.
Deerfield's going to love me on this one. Who's here from Deerfield? Can you tell me your name?
We have Richard Winkleman, and we have I think we also have Dawn.
Yep, I'm here.
Tell me your name, ma'am.
My name's Dawn Epoch.
Do I have anybody else that needs to be involved? Mr. Winkleman, you're on this one too?
I am, Your Honor.
State
And
your
also-
name.
Richard Winkleman.
Mr. Castillo, your name? So.
Your
this
Honor,
was
we also
brought-
have, I'm sorry to interrupt, we also have one more, we have a third representative with Miss Epoch.
Wow, they're teaming up, huh?
We got, just to make the record clear, there is a
Who's
third,
that
there's a
now?
third.
Who's the third representative?
Ebony Riley.
Anthony Riley?
No, Ebony Riley.
Anthony Riley, I'm sorry. I'm sorry. All right. Your name.
My name is Emilio Castillo.
So, Mr. Levine. I know they want this poor guy out. He's got equity in the home. We had termination of tenancy action. One of your lawyers was in here yelling at me about it.
Oh.
I went out and looked at the place twice. He at least cleaned it up enough. So I threw that out. Now we're here for the landlord tenant. I entered a judgment in this case. And Jennifer Wiseman, would you please, or Michelos, whoever, tell me what the judgment amounts was exactly? I read the motion for to stay execution of writ. It says, and I'm going to read this motion for my recollection now more than anything. On April 1, defendant was ordered by this court to pay the outstanding balance for rent by April 13, 26. On April 13, 26 at approximately 6 a.m., defendant deposited money orders totaling $3,300 into plaintiff's design Dropbox. The money orders were purchased on April 12th. Plaintiff advised defendant on April 14th the payment was short, and to retrieve payments, defendant immediately asked plaintiff ability to correct remaining balance. Plaintiff refused additional payment. Defendant remains ready and willing and ready to pay remaining amount immediately. So you guys aren't really going to try to evict him over a $50 shortage, Mr. Levine. Now, I
Your
know
Honor,
you got clients here, but I know you're a good lawyer and I know you're intelligent enough and have enough common sense to say to them, let's back off on this one, right?
And Your Honor, that's why the partial payment that was made late was returned to Mr. Castillo so that he could have those funds back to
It's
him.
made late. He was supposed to pay by the 13th.
And these witnesses, Your Honor, will testify under oath that that money was not in the Dropbox. You have 3 witnesses who will testify under oath that that money was not in the Dropbox the morning of the 13th when they did their deposit from the weekend, and 2 witnesses who will testify under oath that that money was not in the Dropbox at the close on the 13th. That money was not in the Dropbox on the 13th, Your Honor. So the statements in Mr. Castillo's motion are inaccurate, as with the veracity of most of his statements leading up to this hearing. And he was at the prior hearing. He knew how much to pay. He represented to the court that he could pay the total amount right then and there.
I know he
That he-
did.
That he waited until a day after his deadline, and therefore, Your Honor, he failed to comply with the judgment.
Well,
So
that's a
as an
little
attorney-
different if that's the truth. Mr. Castillo. When did you make the payment? Do I have to swear you to an oath?
Yep.
When did you make the payment?
I made it paying 6 a.m. before my workday started. I purchased them at 7 o'clock on the 12th. I have the money orders,
Let me
the
see.
date highlighted. As of the 12th on the back of the 4 money orders totaling $3,300. I informed them that their cameras have me on file and putting it in the Dropbox. I was then informed that their cameras have not worked for a while.
You did tell me. I thought you were going to go. I was shocked to receive this. I thought that you said you were going to pay them that day or something. That we were in court. Did you not tell me that?
The additional fines forced me to wait until my payday of the 12th. Or I'm sorry, the 12th, that following Friday. So I was able to pick up the remaining amount, and
This looks like
the highlighted ones are on the receipts at the back. The 2 new money orders are for the $50 and any remaining late fees. The other 200 money order is in case of court fees. So I sit with 1605, or I'm sorry, 3605.
how much were you supposed to pay?
33 60.
Your Honor, the judgment was 3355.98.
What's this? What's in this envelope? This is from April 22nd, April 22nd, April 22nd, right?
April 12th.
Well, I'm counting here, you've got a money order on April 12th for 1,000, another one for 900. Oh, there was another one stuck here. Another one for 1,000. So 1,000, 1,900, 2,900, 3,300. He's got money, he's got orders, money orders here saying he bought them on the 12th
And
for
Your Honor,
33.
they were not received in the community Dropbox until the 14th. And they did a sweep on the morning of the 13th from the weekend for a deposit and at the close. He did not remit those money orders timely. He had them the whole time. Why would he? Well, I'll leave that.
Yeah, why wouldn't you have?
I did insert them into the mailbox, into their Dropbox on the 13th. As I said, I informed that their cameras have been, then informed that their cameras do not work.
I don't know what the cameras have to do with anything. We have 3 witnesses.
I would not hold on to the money orders for one day to turn them in on 14th. I have call logs from them as they said I was not reachable to return it. I was reached at 10:50 the following morning, informed to come pick up my money orders at 10:54 the 14th. I then went and seek legal advice. Was told to pick up.
Don't tell me what the lawyer told you.
My apologies. I then presumed with my legal advice, and then after I was met with no ability to resolve the situation, I immediately came here and filed the motion. So as of the 14th, my actions on the 14th were nothing more than.
I kind of felt like a babysitter on this, to tell you the truth.
I understand.
Do I really have to conduct a hearing here, Mr. Levine?
Your Honor, my client yes, you have to conduct a hearing. There's been a complete disregard for the rules and for payment. And he misrepresented himself to the court by saying he could pay that day and then waited until on his own testimony,
Did you?
12 days later and was short.
Why did you?
And so nothing's adding up.
Wait. Why did you? Didn't you tell me you were going to pay that day?
I had 90% of the payment.
Well, you didn't tell me you had 90% of the payment. You said I'm going to pay it all today. I have all the money. Did you not say that? Am I crazy?
No, you are not.
Well, then why'd you tell me that if that wasn't true?
That day I was not able to get an advance on my check to get the remaining amount for $200.
Well, why'd you tell me you had the money?
I believed I was able to get the $200.
You weren't being honest with me. You weren't being honest with me. All right. Well. Let me take a 5-minute recess, okay? I'll be back here in a few minutes, everybody. Just be patient with me, please. Thank you. Emilio Castillo, 2600528. How do you do? One back.
Morning again, Jarrett Levine for the plaintiff.
Mr. Castillo, your name.
Castillo.
All right, so now again, I'm going to take testimony. Now I want the record to reflect that in front of me. Mr. Levine, he also has equity in this. I mean, I've got a heart. I just want you to know he's got equity according to him. I remember covering that with the termination of tenancy. And I'm not condoning somebody being late, but I don't know why in the world, unless he just wants to make an issue of this and make me think, why he would go and get money orders on the 12th. And I've got them. 900, 1,000, that's 19 plus 400, that's 23 plus 4, wait a minute. 1,000, 1,900, 900, 1,000, that's 29 plus the 4 is 33.
Your Honor, there's a difference of opinion on the equity, but if he does have equity like he says he has, he can take that home with him when he leaves. It's his home to take with him when he leaves. And if he thinks it has
Listen to
equity,
your witnesses. I'm not going to prevent them from testifying.
thank you.
But if they got it on the 14th, then I want everybody to know that. Who do you want to testify first?
We'll start with the property manager. Dawn.
And your name again, ma'am?
My name's Dawn Epoch.
And you are the property manager, correct?
Yes,
Raise your right hand. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole true self you got.
yes.
Mr. Castillo, you can have a seat there if you want, or you can stand, whatever you prefer. Go ahead, Mr. Levine.
Thank you. Ms. Epoch, what is your position with Deerfield Estates?
I'm the community manager.
As a community manager, are you familiar with Mr. Castillo's payment history?
Yes,
And do you handle the deposits from the Dropbox?
it's either me or my assistant Ebony.
Is that who's sitting behind you?
Yes,
On the morning of Monday, April 13th, did you handle the deposits out of the Dropbox with Ebony?
I did not that day.
I was with Richard.
Ebony did the deposit.
Ebony did the deposit.
Mhm.
And did you do the deposit that afternoon? Did you
I-
review what was in the Dropbox that afternoon?
Yes,
Yes. Did you review what was in the Dropbox the morning of Tuesday, April 14th?
yes.
When did Mr. Castillo's payment totaling $3,300 appear in the Dropbox?
That would be Ebony.
Oh.
We both check it.
You both check it, but you
Yeah.
didn't
They're on
find
the
it.
13th.
It would,
Which,
What's that?
Ebony checked
You
it
s-
on the 13th. There.
right. So why am I hearing from her? Did you review? Okay, if Ebony acquired the payments out of the Dropbox on the morning of the 13th, did you look at them later in the day to see who had paid?
Yeah, I check it throughout the day.
Hang on, your name
Okay.
again.
My name is Ebony Riley.
And spell your last name. I didn't catch that.
Yes, my last name is Riley.
Riley, okay. I'm sorry. Raise your right hand, Ms. Riley. You solemnly swear or affirm under penalties of perjury the testimony you'll give in these proceedings will be the whole true self you got.
Yes,
Did you go to the Dropbox on the 13th, morning of the 13th?
I did.
What time?
I get here around 9 o'clock.
How many payments were in the Dropbox the morning of the 13th, which was a Monday, by the way, right?
Yeah, Monday. The morning is probably, I think it was about 2 or 3 on Monday morning.
If somebody puts their payment in the Dropbox on 12th, nobody would be there to pick it up until the 13th. Is that true or false?
True.
So when you went into the Dropbox on the 13th, how many payments were in there?
2 or 3. I don't remember exactly, but it wasn't that many.
What did you do with those?
When I get them, I look at them, I open them, and then I deposit them into the person's account.
Was there a payment from Mr. Castillo in there on the morning of the 13th?
No, there wasn't.
And again, what time did you check that at?
I get in at 9, so probably right when I come in between 9:05.
All right, who checked the box on the 14th? Was it you, Ms. Riley?
Yes, it was.
What time?
I checked it around 9 o'clock again.
Was there a payment in there from Mr. Castillo on the 14th?
Yes, there was.
And how many days do you check the Dropbox?
I check it every day because it's in my room.
I know, but how many times do you check it?
I check it throughout the day because I see when people come up and when they drop it. So I just grab it, or just throughout the day, just look to see if something had fell into the Dropbox.
Do you remember whether or not you checked the Dropbox more than once, that being at around 9 o'clock in the morning on April 13th?
I check it throughout the day. So yeah, more than once.
How many times? Well, I'm asking, did you check it? Do you specifically remember checking it last Monday, April the 13th, after 9 a.m.?
Yeah, between 9:05. Yes.
Listen to my question.
Okay.
Do you specifically remember checking it after 9:09 or 9:05 a.m. on April 13th?
Yes.
Can you tell me what times you also checked the Dropbox on April the 13th after 9 or 9:05 a.m.?
I don't have like times, but it's just throughout the day.
How many times throughout the day?
Multiple times, maybe 5, 6.
And you have no reason to dispute that his payment was in there the morning of the 14th.
His payment was in there on the morning of the 14th.
When is the last time that somebody checked the Dropbox on the 13th?
I check it
Or that you did. When is the last time you checked the Dropbox, if you remember, on April 13th?
Yep. It will be 5 o'clock. We close at 5, so I check it before we leave out.
Ms. Epoch, what time did you last check it on the 13th?
We knew Mr. Castillo's deadline was the 13th, so I checked it also. And I stay
that?
after 5, and I checked it before I left.
What time did you leave?
I usually leave anywhere between 5:15 and 5:40.
All right. And so if he put it in there after 5:15 or 5:40, what time would that have been discovered?
The next day.
Right. Can anybody swear under oath that he didn't drop it in the Dropbox on the 13th?
That he didn't?
That he did not. It was in there the morning of the 14th,
Mm-hmm.
right?
Yeah.
Can anybody testify under oath, whether it's Mr. Winkleman, Ms. Epoch, or Ms. Riley, that can testify that it definitely was not in the Dropbox after 5:30 or 5:40 or 6 o'clock on Monday, April 13th?
It would be after the close of business, Your Honor. There would be nobody there to check that.
Well, I know, but what if he put it in there on the 13th? Would that mean that it was not effectively presented on or before the 13th?
I mean, my response to that is, why did he take so long? And he told us he did it on the 13th in the morning. His testimony to the court was that he did it that morning. He didn't say he did it in the afternoon. He didn't say he did it after hours. He didn't say he did it at 6 o'clock or after they left. He said he did it that morning. And the testimony you heard under oath was that payment was not in the morning, and it was not in when they closed, and they even stayed late. So
You're under oath.
statements.
I'm going to swear you in, if I haven't already. Do you solemnly swear or affirm the testimony you'll give in these proceedings will be the whole true self you got?
I do.
Now listen to me. You are under oath. That's serious. You understand that? You told me in court, not under oath, you were going to go and pay the whole thing and that you had the whole thing on the date that you were last in the courthouse.
Correct.
Didn't you?
Correct.
That wasn't truthful, was it?
No, I did not have the full amount that moment.
But you chose to tell me that you had the full amount to pay, true?
Right.
And in fact, I think if I went back and listened to the tape, the time before that, and it could have been in conjunction with the termination of tenancy action, you told me you had the money to pay in full. Did you or did you not?
I did. That was not the following month added.
Times you put this money in the Dropbox.
6 o'clock in the morning,
What day?
April 13th. I purchased them Sunday, April 12th in Kroger, 7 o'clock. I submitted them into the Dropbox at 6 a.m. before I left that day.
And you put in 3,300, correct?
33 for 33.59.
Why didn't you pay 33.59?
My understanding was 33. I was wrong. I didn't know that I didn't calculate the 60. I was unaware of the 60. So,
All right, hang on. Mr. Levine, I'm gonna let you ask him any questions you want. Did you hear me, Mr. Levine?
Yeah, yes. Did anybody witness you, Mr. Castillo, putting the money in the Dropbox?
there were no human witnesses, as I informed him that his camera pointed toward the Dropbox should have me putting it in there at that time before I was informed that they do not work.
I'm not sure what the camera has to do. So nobody saw you put the money in the Dropbox.
It would have only been their security cameras.
You typically pay by remitting payments in the Dropbox, or you take them into the office?
I typically remit them into the Dropbox.
You ever get a receipt for these payments?
Only if I'm able to drop them off in person, very few receipts.
Wouldn't you think that something this crucial facing an eviction would warrant a receipt and to go into the office?
At this point in time, my better judgment says that I should have, yes.
So it's your testimony that you dropped these money orders in the Dropbox on Monday, April 13th at 6 a.m.
Absolutely.
I have nothing further, but I have one rebuttal witness in Mr. Winkleman, who was there the morning of the 13th.
Who do you want to testify?
Richard Winkleman.
Mr. Winkleman, tell me your name, please.
Richard Winkleman.
I'm going to ask you to raise your right hand. You solemnly swear affirmative penalties of perjury, the testimony you give in these proceedings will be the whole true self you got.
I do, Your Honor.
Okay, go ahead.
Mr. Winkleman, please state your position with Deerfield Estates.
I'm the Director of Community Operations.
And how long have you held this position?
Over 11 years.
How long have you worked in the manufactured housing industry?
Over 30 years.
Were you present at the Deerfield Estates office the morning of April 13th?
I was.
Were you there when your office staff did the deposit from the Dropbox?
I was there when they checked the Dropbox, yes.
When they checked the Dropbox. Was Mr. Castillo's payment in the community Dropbox on Monday, April 13th, when you were there and they checked the Dropbox?
No, it was not.
But that's based strictly on what the employees told you, right? Either Ms. Epoch or Ms. Riley. You didn't actually physically check it, correct?
I was there when the envelopes came out of the Dropbox and there was no payment from Mr. Castillo.
Okay, go ahead, Mr. Levine.
Nothing further.
Do you have any questions that you want to ask any of these witnesses?
Nothing that would change the outcome. I think, go on.
What does that mean? I don't know what that means.
My questions at this point would just seem stonewalled. They wouldn't give me the remaining amount that I owed to fix the situation on the 14th. Every question I got was referred to with you have to speak to our lawyers.
Any argument?
And just briefly in response, Mr. Castillo has participated in this case. He was aware of the amount, and there's a judgment that was entered that reflected that amount in writing, with the court finding the exact amount to be paid and the deadline to pay it. We're asking the court to enter the order of eviction and authorize the eviction.
Anything?
Nothing further than why the cameras don't work that are pointing toward the Dropbox. Because the rent has been stolen out of there once at least.
Is it a lockbox, Ms. Epoch?
It's just like a little drop box that when you put it in, it goes straight to the floor into a box. There's no lock.
Why are you saying that some money's been stolen out of it?
Oh, no, it had happened before. During the time that I lived there, money orders had been stolen, so I was curious why the cameras don't work to show that I was there that morning.
Were money orders stolen before?
I've only been here for 6 years, so not in my time.
Look, I don't know why somebody would go and get, and I'm not accusing anybody of lying here. Let me be clear about that. I don't know, but I don't know why somebody would go and get money orders on the 12th and not put them in the box until the morning of the 14th. It doesn't make any sense to me. I've got the receipts right here. He clearly got them on the 12th. How far are you from the office?
I'm less than a mile, not even on the first street.
So it doesn't make any sense. I know he's $59 short. I'm denying the motion, or I'm granting his motion to stay the proceeding. I'm going to find that the judgment has been satisfied. So I'm sorry. So the motion to stay of execution and writ of eviction is granted. Motion to stay execution and execution of writ of eviction, I should say, is granted. Judgment deemed satisfied. He has paid the other $59, right?
No, he has not, and he still has the money. So the judgment's certainly not satisfied.
I'm going to hand you back all of your sheets here, all of your property. I do want to make copies, Jennifer, please, of the money order receipts. I'm going to hand him the money orders right now. You are to pay in the order. Jennifer, prepare an order that the motion to stay of execution writ is granted. Defendant has paid $3,300. The remaining judgment amount shall be paid by 4 p.m. today. By 4 p.m. today. Do you understand that?
It'd be put in.
Your Honor, he still has the 3,300 though. Are we walking when we're not physically in court with him? So he needs to remit all of it. Because we don't have any of those payments.
It'd be there than all that is.
Oh, because you returned it, right? Because they returned it?
Yes, because it
Yeah.
was late.
Yeah, so I'm sorry, you're right. My apologies. Motion to stay execution writ is granted. All monies due pursuant to the all monies pursuant to the judgment. I don't know what date it was entered. I don't have that in front of me. Are due by 4 p.m. today. And you are to go in there and you are to get a receipt for payment. Do you understand that? I'm handing everything back to you. Thank you. Thanks, guys. Have a great day.
Thanks, Judge.
William Walter Mulhern, 24W8333054. Your name?
William Walter Mulhern.
All right, so I set this for sentencing this morning. You pled guilty.
Nobody's answering probation.
You pled guilty to this violation here. And the violation alleged that you failed to submit the twice weekly testing on April 4th. And that you failed to refrain from consuming alcohol or controlled substances. And that you submitted that you were positive on a test for cocaine on April the 6th. I told you I wanted to schedule this for sentencing. Before we go on, I want to advise you, you have the right to an attorney. And I'll be happy to provide you with one at public expense if you would like one.
No.
Would you like one?
No.
You pled guilty here to attempted possession of a controlled substance. You were on probation on the sobriety court for 2 years. I was told that, so therefore you have 5 days credit coming. I don't remember if I gave you credit. Were you arrested on the date of this? I'm
No.
talking about on the date of the offense. September 5 of 23.
Yeah, they took me to jail and, they never held me.
Okay.
Let's go probation.
So on my view, do you want a lawyer first of all?
No,
Are you sure?
yes.
So you have 6 days coming. Credit. Anything you would like to tell me?
I made an appointment. I talked to that over there and I shouldn't say this one, but I went to pay my insurance to $800. And then I called around all day. Either they'll accept my insurance because there's a waiting list, but they don't pick you up from jail, or they only do it with the state insurance. So I went ahead and I called my doctor and made an appointment later on. It's May 28th at 8 a.m. with Miss Akram to get a referral to see a psychiatrist because I think I need medication. That's all I'm saying.
How?
I've been just
Wait, slow down. Have you figured something out here?
So he has Blue Cross and Blue Shield. So
Right.
after court last time, we talked again. And the plan was for him to renew his insurance because as long as he has private insurance, he can only go to what would be obviously in his neck. So he had been to Elmhurst before, and that was kind of the goal as he left was to get with Elmhurst. But as Bill's indicating, there's a waiting list for private insurance. If he was on Medicaid, Medicare, if he was going through DWIN, they got beds available, but he can't. They won't give that bed to a private insurance. He really is in a hard place. Not to his fault. He did make every effort. He showed me his receipts.
Tell me how you think I can handle this appropriately.
I don't have him. I really would have loved to see Bill go inpatient for the full time. No jail, go inpatient for the full time. The bad part about waiting lists is it's not something where, well, we have a bed available on this day. If that's
Will they transport him? How can I word this commitment for the jail?
the jail has to have who's paying for the treatment. And obviously then, the agency and the pickup. Elmhurst is no longer doing the pickup from the jail. I am not aware of any agency at the top of my head that has the jail pickup. Bill checked with, I think he rattled off about 7 probably different agencies to me.
I called.
None of them do the jail pickup.
I called in Clarkston, Inside in Brighton. It's just,
How am I gonna do this?
So the only thing that I can think of, Judge, if the gold pierce treatment, which is obviously, I think what everybody has in mind, would be for him to call. I'll just use Elmhurst as an example because again, he's used to Elmhurst. Is to call it and get an exact date for the bed for private insurance. And have him go straight to inpatient on the private insurance on that date. It can be where if he doesn't go and we don't get proof, then the alternative is the full 40 days jail, or 39 at this point, 39 days jail, you know, with the credit sense.
I just want it solved. It's just it's too frustrating.
I know, but you have no idea how much this is disappointing.
I understand I let you down, but
It's not letting me down. You let yourself down. You ran a marathon.
You put a seed in me, believe me.
You ran a marathon. You stumbled when you got 600 yards from the finish line, and then you stumbled. You stopped running 7 yards before the end of the marathon. I don't get it. I don't understand what you were thinking.
Just go.
Bill.
It's not an excuse. I didn't take accountability. I just got about.
I was.
I know I could have zoomed in that day, but I'm glad I didn't. I wasn't ready. Believe me, these last 3 weeks at home and looking at her and knowing what I did to her. I'm good. I'll get the help I need through my doctor. I know you don't believe it, but when I get out of jail, I'll get the help I need from the doctor.
If he does go in custody today, Judge, the jail should, obviously, we don't have control over what they do, but they should allow him to continue to make calls to see if a bed's available. I am not sure how that works as far as the commitment, if he does have a bed available, if a new commitment can be sent over to allow him to go inpatient after so many days in custody.
Just go to jail.
I don't know how to word this. My thought process is 15 days jail, and then I'll release him to inpatient treatment for the balance.
That would be appropriate, and it would allow.
But then the problem is, who's going to get him? How are they going to know? Well, he's in a bureaucracy. Wait, hang on. He's in a bureaucracy down there. How's he going to get proof that he can go into inpatient?
Yeah, I don't know if they're going to allow him to make those types of phone calls. I don't know if the jail does that.
And with my insurance, they're not going to accept me. So it's just too big a hassle. I'll go to jail. This is my problem, not yours.
Tell you what, I'm going to leave it like this. Probation's revoked, you to serve 45 days, credit 6 for 39. If you can get me proof, I don't care who's this with you?
My sister.
If your sister can get me proof that you're eligible for there's a bed available at Elmhurst or any other place after 15 days, I'll be more than happy to do an amended commitment, have you released, but it's going to be contingent then. I'll even write it down.
You don't have to. It's a 3-month program with Elmhurst, and I have to get home to her, so I'll do the 39 days. I don't want to prove that I did it. There's no going back.
Well, I'm just telling you, I'm making that available to you. If after 15 days you want, I'll be happy to do this. This pains me gratefully. We have to revoke. Remind me, he had an interlock, right?
No. Bill's offense was not a.
Right. What am I thinking? Thank you. Good luck, Bill. I hope you'll come back and tell me you're
Thank you for
doing well.
everything. You don't, I'm sorry.
It's all right.
Court calls the case of the People versus Cheetos by Hodgino. Why? Oh, no.
Your Honor, bring the people.
Your Honor, good morning. The Office of the Public Defender does not believe a conflict exists between this honorable court and the Office of Public Defender. But if one were to arise, we would waive any claim that a conflict exists.
And Your Honor, people do not believe that there is any conflict present. Well, in the event that conflict were to arise, the people would similarly waive any such.
Court also does not believe there's a conflict either in the Michigan court rules or the cases decided thereafter. To the extent a conflict does exist, given the waivers, court will consent to hear plaintiffs. All right. Mr. Brown, we have a bond violation.
Yes, Your Honor, I've shared it with my client. He will admit that he tested late on the dates contained in the report from April 15th, authored by Community Corrections Supervising Agent Charles Mormon. I can give the court some background.
Go ahead.
Present here with his mother, who took her time out of her day to come see about her son. What was going on with him? He was working at, I believe it was Burger King on Stadium, Taco Bell on Stadium, and he worked 4 night shifts, and his biological clock was thrown off by some of those hours. So, for example, he'd get off work 3 or 4 in the morning, and then he was supposed to test between 4 a.m. and 7 a.m. and fall asleep. But he'd wake up and then he'd test, and his tests were negative for any controlled substance.
Why did he test it? I mean, there's a 3-hour window.
You sleep after working a shift at kid, 24 years old, Your Honor.
But we had sent to him, I mean, there were times before this at the problem, and we had sent an order to comply to him back on March 9th, so not taking any action. And then he was good for about 10 days. And then proceeded to have 1, 2, 3, 4, 5, 6, 7, 8, 9. It's test.
Missed, but they were compliant. No alcohol. If we're on page 2.
I understand there's no alcohol, but I could consider these violations. He's supposed to test in that time window.
And I've impressed that upon him, Your Honor. That's why he's here. Also, he's now left Taco Bell, and he's at doing landscaping, and he's advised his agent. So they adjusted or tried to accommodate his work schedule, landscaping now. And I have his works.
How is that going to work? Landscape. That could be even more problematic.
I talked to him about that, but he thinks that he's worked it out with his agent so that they now have a plan so that he's going to comply and test during the windows that you've ordered.
Anything from the people?
The court indicated the court was quite clearly about the April retrial. There was not to be any more late tests, and unless we've gotten this late tests, I think the best way forward is frame tether. That way, there can't be any late tests, and we continue monitoring the defendant.
In his defense, Your Honor, he was seen by Mr. Statman and got his assessment on April 17th. So we are trying to move forward with the case. We're not dragging our feet, and I'm not changing the subject, but he's got a new job and he's trying to do better. And he's got his mama here in court today. Ma'am?
Oh, I see her. All right.
Did I miss anything? Okay.
Only there was some time that he wasn't able to change the testing schedule when he switched jobs and switched schedules. I think that was an issue.
And ma'am, for the record, what's your name? Sarah Ladd.
Mother's Day is coming, Judge.
What am I supposed to do with that?
Mother's Day is coming. I mean, it says a lot. She's standing up for it.
I get that, but I mean, I've got 14 missed tests.
Yes, Your Honor, but no alcohol. She'll tell you he's not drinking.
Young man, when you got the order telling you to comply, no more late tests, and when I told you at court, no more late tests, what were you thinking?
To just try and get them on time. Try to not go for any more late ones, but sometimes I just lose track of time when I'm at work. Most of these have only occurred when I'm physically at work.
Young man, tell me why I shouldn't just throw you in jail. You don't listen to the court's order. That's 2 orders you haven't listened to. Yeah, the first order telling you to test, and then I sent you another order telling you to comply.
Well, I don't think I should be put in jail because I'm besides being late, I'm complying with everything else and doing exactly what I need to be doing. Not touching drinks, just working and doing what I need to do.
What about your association? You still hanging out with the same people you're drinking with?
No.
What I'm going to do is, defendant having admitted to violations, I'm not going to incarcerate you at this time yet. But you're going to go over to community corrections, get placed on the Graham tether. Any types of violations, such as not being charged, not properly downloading, all of those things. If you don't follow that to a T, you're going. Am I understood? I didn't hear you. Thank you.
Yeah.
Do you have the unit with you?
Yeah.
You take that over and they'll fit you with the scram tether. Court does call the case to reverse Connor Kearns. Oh, it's already.
Okay.
Yeah, this was a bond violation.
Bond violation. All right.
Court does call the case versus Connor Kearns.
Alexander, on behalf of the people, Your Honor.
Morning, Your Honor. Richard Blifford on behalf of Defendant Kearns here in the courtroom with me. Your Honor, today's date and time for an emergency bond violation hearing. At this time, the defendant is going to acknowledge the allegations that are set forth in the complaint.
Bond violation.
Bond violation, correct.
Okay. Anything from the people?
Your Honor, I'll just rely on our previous motion. I do want to say, I did mention that there could be a potential for future charges. I do need to get a little bit of further investigation done before I make a final decision on that for both defendant and defendant's mother. They were both submitted on by Ann Arbor Police.
Who was?
Defendant and defendant's mother.
All right. Okay. Anything you want to say?
There actually quite a bit I want to say, Your Honor. Defendant is the parent, is married to the victim in this case. There's a highly toxic and dysfunctional relationship with victim. The victim sought a PPO. There was never any allegation that there was striking, hitting, assaultive behavior in the PPO. There's more threatening behavior and things of that nature, but not like I've been punched or I've been hit or anything like that. In any event, the PPO was put into place earlier in the winter. The PPO obviously was at the choice of the victim. I'm just going to lay it out for you, Your Honor, and maybe in a way that's not helpful to my client, but I'm just going to lay it out for you. These people have been in non-stop communication with each other since the day the PPO was granted. Hundreds and hundreds of text messages. I just looked at my client's cell phone log this morning before in the hallway before I came in here. Hundreds of text messages, including, Your Honor, more than 25 text messages yesterday. The parents have a child together. The child's birthday, his first birthday was on April 12th. The parents went to church together on April 12th for a birthday party for the child. They visited with the fire department and took the child on a ride in the fire truck together recently. The victim, I read through every one of these texts, and as an officer of the court, I could tell you that there is not a scintilla of evidence that indicates that the victim is scared of the defendant. The victim is asking the defendant to come and be part of her life. The defendant has Venmoed the victim thousands of dollars since the inception of the PPO. How does he Venmo her? She calls him and says that it's money, and he Venmos her money. The victim has shown up at the defendant's house. Defendant has been at the victim's house. It's a highly dysfunctional relationship. Some of the texts, Your Honor, that the victim has given I read this morning, some of the texts, the victim is advising the defendant on how to beat this case, on what strategies he needs to be using to beat this felony case against him. And so I'm making some admissions to the court that maybe under some circumstances would be against the best interests of my client, but I've been in front of you, Your Honor. I know you're a straight guy, and I think the court would rather hear this than some nonsense. That's been the relationship that's going on here. The defendant is 31 years old, Your Honor. He's a honorably discharged member of the United States Army, served in the airborne, served in Ukraine, served on the border of Syria. He receives an 80% disability payment through the Veterans Administration for some lower back issues as a result of parachuting. He has been enrolled at Washington County Community College, and on May 6th, he's supposed to receive his associate's degree in transportation technology. So he's been involved in a 2-year program. He's supposed to graduate from that program in the next 2 weeks, Your Honor. He has final exams coming up in the next few days. Court can see his parents are here with him. They share with me, and the victim and the defendant shares with me that there is some counseling that he can get through the VA that would probably be appropriate. As an attorney, and I know you're an attorney, it's frustrating to me that the defendant has conducted himself in this way. I've shared my frustration with him about this. It's just very frustrating that I can't impress upon him or I haven't been able to as of yet, that I don't care if she shows up at your house. If she shows up at your house, you run in the house and lock the door. That's what you do. And that's how you handle it. And so there's been some monumental bad judgment here. In regards to this allegation of an ear tag being put in her car, the defendant says that took place at his house with the victim participating in this. So,
excuse me, that he and her did it, that they did it together?
He said that she came to his house unannounced in Ann Arbor, his parents' house where he lives. They discussed putting an ear tag in the car so he would know where her and his child is, and she said that would be a good idea, and the ear tag was placed in the car. And
that's true. Then why does she have concerns when it alerts her phone?
Because it's a highly toxic relationship, Your Honor. The parents are trying to evict the parents are in the process of evicting the victim from their condominium, where the former marital home. The parents are the owner of that home. They're in the process of evicting it. It's a cluster of incredible proportions that are happening here. The amount of legal fees in this case are eye-watering, Your Honor, and it's just. I think that I come here today asking that the defendant be given another chance, and I can't promise the court that he's going to be able to control himself to not communicate with this person. I think that this brings it to a level of seriousness that we haven't seen up until now. But I think that he deserves another chance. There's no allegation of physical.
Well, and maybe counsel, and I get that they've got a child together and that there might be some conduct, although there shouldn't be.
Hundreds and hundreds.
Right. But the problem is he's the one under the court's jurisdiction. And I know you know this.
And
he's the one that cannot have that conduct.
And I've told him that. His parents have told him that.
But what I don't get is I don't understand this air tag. That if they're having so much contact, why do I need an air tag?
Well, I mean, I could just tell you anecdotally, on my phone, I can see where my wife is at all times, and so
I can do that without an air tag.
Yeah.
All she would have to do is share her location with him, and he would know.
Your Honor, all I can tell you is I'm seeing texts as early as this morning at 9 o'clock, at 8 o'clock this morning, texts from the victim saying, I'm going to the prosecutor's office because this is all a big misunderstanding. I'm not making that up. That's the text I see from the victim at 8 o'clock this morning. Okay. I saw the same text from the victim 3 times yesterday. She texts him that this is a terrible misunderstanding. And so the defendant is here. He's executed, he's demonstrated monumental bad judgment. We're here falling on our sword. We're not here trying to say that this didn't happen. I told my client, what are you going to do? You're going to come tell the judge you didn't do this? You're not going to lie in court. And so we can't do that. That's not an option to come to court and deny this. That's just not an option. It's not an option for me as an attorney. It's not an option for the defendant. And so there's just bad judgment here. I'm hoping the court could give him the proverbial second chance. I'm hoping that you could impress upon him the seriousness of this. But I'm asking you not to take him into custody, Your Honor. I just don't think it rises to that level.
Counsel, let me just say this. I hear what you're saying about the contact, and that shouldn't even be happening, and I'm sure you're after about that. It rises to a different level when I'm tracking your whereabouts. That's my problem.
The defendant tells me that this was done cooperatively between the parties. And
then I heard you the first time regarding that, and I don't believe it. The reason I don't believe it is because he obviously hasn't been following the court's orders, but also that the whole tenor of the police report, which I'm sure you got a copy of.
I did.
Doesn't indicate that this is anything cooperative on her part.
I know, but Your Honor, this is also somebody who went and sought a stalking charge and then went and contacted the person saying, this is the police understanding here. I never meant to see you charged like this. So you have a very frenetic victim here who is, on what day of the week. It's a toxic relationship. These people do not do a good job communicating with each other. So if for chance, you know, she asks for a Venmo and it doesn't go through. Guess what? She's off to the police department. I mean, that's the nature of this relationship. And that's something that needs to be resolved via the divorce. But I mean, this is an insane relationship here. And it from what I gather, and I'm not a testifier, from what I gather, it doesn't rise to the level of striking each other or hitting each other in the face or that type of thing, you know. But as far as you know, daggers out and just sort of crazy conduct, these people are involved in a spiral of crazy conduct with each other. They're both part of this crazy conduct, both of them. But you're right, Your Honor, the defendant is the one who's here in court. The victim is not in court. She's not on the court doesn't have jurisdiction over her conduct as to whether she shows up at his house. And so it's just been bad judgment. It's terrible judgment. And, you know, that's it's funny because, you know, I thought long and hard about this weekend. What am I going to say to you? I really, you know, belabored in my mind, what am I going to say to you? And this is what I'm going to say to you. And I think he deserves another chance. I do believe he can fly straight. And that's our prayer to the court, Your Honor. So
Yeah, I did also want to note in the court that our victim advocate did speak with the victim today, and I also spoke to the hallway. That's where I was before this, and I didn't have any mention of any of that, including the cooperative air tag on her part. I told her she can leave before this because she was not testifying. She wanted to leave. She didn't want to be present today in the courtroom, but she did not mention any of that, and I have not seen any of these texts either.
But she did not indicate that this was somehow cooperative or somehow
No, Your Honor.
that the police report itself was some type of misunderstanding.
No.
Did she indicate to you that the entirety of the case was a misunderstanding?
No, she informed me that, and I was just throwing, she wanted him to get out. And she was concerned about his parents and what was coming with that. So she just had concerns with what was going on.
There's a highly conflictual relationship between parents and the victim as well. It's like, it's off the charts, Your Honor. Mainly revolving an eviction.
How old's the child?
The child just turned 1 year old on April 12th. That's when
This is the part that's phenomenal to me. I've got the parents at each other in some way. Well, I think somebody may have arrived. Sure. I've got the circumstance that the parents are at each other. The parents of the child are at each other. Defendant, his wife are at each other. There's a divorce going on. There's then this stalking case going on. There's then going to be, thank goodness, the premises, I think, are in Ann Arbor, so it's not my jurisdiction. There's then going to be an eviction that's going on, which makes no sense to me. Everybody keeps raising this to whatever level. The other concern that I have is, and counsel, I get what you're saying to me. Trust me, I do.
Thank you, Your Honor.
And I get the notion of periodically through the weekend after I'd seen the motion, I'm trying to figure out what was he gonna tell me after I went through and read the police report and everything. And I don't want to necessarily escalate it, but I'm having a difficult time believing, with everybody operating with iPhones, that the purpose of that tag was as you said it was. She's here. If you want me to put her under oath, and then I'll figure it out that way. But if I get that clients tell attorneys things, and I get that then the attorney has to come up and you have to say what the client's telling you. I get all of that. But I'm telling you, that notion of why that tag's there doesn't fit with anything I see in the police report. Doesn't fit, and maybe in certain relationships doesn't fit with any common sense I know of, but that can happen. But it doesn't make any sense. And now that she's here and Miss Linda, I'm presuming available to testify before the court, if necessary.
Yes, but if that were the case, I would ask to briefly pass it so she could speak with my victim advocate. And
Understood. I don't know. Well, hold on a second. I don't know if your client wants to change his position on what he's had laid to this court about that air tag.
If we could pass the matter, and I would say to the court that we're not necessarily hearing testimony day. But
oh, I know, and I'm not, and understand that
but
let me just say this. I look stupid, but I'm not. And the problem is that I realize your client has said that to you, you've related to the court. I don't doubt with regard to any contact that you told him what you said you told me. I don't doubt any of that. I'm just having a real tough time believing your client's premise for why that's. And I'm sure because you have been before me. And one of the things, the worst thing is, if you lie to me, we're going to have a whole other set of problems.
Understood, Your Honor.
So what I will do, knowing that she's here and that I may take testimony, I'll pass the matter so that the victim's advocate can talk with her. You can talk with your client, and then somebody wants to give me a story that makes some sense. Fine. All right. He is to remain in the building. It's not to leave.
Of course.
All right. All right. Is that all I've got for 11? And why is he here yelling at me then? He's over there screaming at me. Judge, get moving. I'm sorry. That's what I heard. I don't know. Court's gonna stand in recess.
All rise.
Court recalls case People versus Connor.
as another people, Your Honor.
This time the defendant is offering a no contest plea to the allegation, that being that he's able to articulate the facts, and we would stipulate to the police report as a basis.
Anything else from the people? This time, this is currently set for the ECC, I think this Thursday. So we'll continue the matter to the probable cause conference this Thursday at December 23rd. April 23rd, 2026, 9 a.m. At this time, given the admission to no contest, but admission to the violation, the defendant's bond at this time is revoked. Defendant is remanded.
Thank you, Your Honor. Thank you again for your time.
Thank you, Your Honor.
Court does call the case, People versus Terrence Smith.
And Lisa, on behalf of the people, Your Honor.
Ron Brown, appearing on behalf of Terrence Smith.
Name? Terrence Smith. Thank you.
Your Honor, we'd ask the court to set a jury date in this case, and I'd like to argue bond.
Jury final settlement conference will be set June 5th, 2026, 9 a.m. Jury selection, if necessary, June 8th, 2026 at 8:30. As to bond.
Your Honor, I believe Mr. Smith's bond was revoked at his prior hearing on Thursday at PCC hearings. Since then, I've attempted to reach out to supervising agent at Community Corrections to answer questions that the court had concerning the violation. Specifically, my information is that Mr. Smith received word that he had been in violation at 1:50, at 1:58, 8 minutes later, exited the exclusion zone, Your Honor. My information is from talking to Brian Casey, the supervisor over at Community Corrections, that it was the supervising agency that reached out to him, but he was under the misplaced perception that he was talking to Mr. Brian Levitt, the supervising agent, but instead it was JSG, I believe, supervising agent for the tether company that he was speaking to in reference of the violation and his need to get out of the exclusion zone, in which he immediately did. My further information is that
8 minutes after being in, he got up.
And he was not in contact with the complaining witness. My information is that he went there to assist a family member, a cousin who was moving, and he needed to get some money. And the reason that he went there was to assist in moving. But once he found out that the address that the cousin was moving from was within the exclusion zone, he left. No contact with the complaining witness whatsoever, Your Honor. My further information is that I'll leave it at that right now, other than he needs to get out to assist with childcare. Is that what you told me?
Yes,
Childcare, as it relates to a child in common with the complaining witness.
Yes, sir. You respond to me.
At this point, I'm going to object. This violation of the exclusion zone is extremely concerning to people, given that this domestic violence case occurs at where the exclusion zone is. Then he picks up another felony case for assisting and obstructing at that same location. And I have concerns now that he's going back to that area. He's there for 8 minutes, and I don't know if he contacted his actual agent rather than just the JSC. It's not in the report, and he was there for 8 minutes.
I attempted to contact the supervising agent on Friday, but was informed that he was out of the office. Again, this morning before court, I went over to Community Corrections. The supervising agent wasn't available, and I spoke to his supervisor, Brandon Casey, and I relayed the information from the notes, I believe, in the supervising agent's file through Mr. Casey. Your Honor?
Yes.
Is he on remand or is there a cash component right now?
Cash component.
Would you consider a cash component?
Not at this time. What I will do is his bond will continue as revoked, given the violations that the court sees. However, I will set a pretrial or a bond hearing for May 4th, 2026 at 12 noon. And you can provide the additional information if you get it.
Would that be can we sign the waiver right now?
Sign what waiver?
Oh, I'm sorry. I misspoke.
Well, thank you.
He's
We will go on the record in the matter 25 CF 36, State of Wisconsin versus Christine Stewart. This date appears through District Attorney Kevin Schmidt in person. We have Ms. Stewart appearing in person with counsel Emma Campion. We're set here today in this matter for a plea and sentencing. The parties have reached an agreement. Can you please recite it for the record, Ms. Campion?
Yes, Your Honor. Ms. Stewart will plead to count 2. Counts 1 and 3 will be dismissed and read in. The parties jointly recommend a withheld sentence and a probationary period of 18 months. Believe the conditions recommended are an AODA assessment and follow through and absolute sobriety.
Basis for the public interest, Mr. Schmidt.
Judge, with the conviction that's resulting today, there's public accountability for what happened here. These were both individuals who were not known by law enforcement to be selling. They were not names that were coming up as they were dealing with people in the community or informants or anything like that. The manufacturer count is the most serious count. I don't think prison or jail is necessary on this offense for those reasons. When you looked at the setup they had in the basement, it's reminiscent of what I'd say some people make like microbreweries, like that kind of analog to it. The limited evidence we had for sale was the daughter said she saw mom exchange some for money one time in the parking lot, and they had a notebook that had some names on it. It was somewhat ambiguous. And even if you did take that to be some sort of drug ledger, there are only like 4 unique names on it. So it's not like, it was probably just giving to friends is what I would estimate.
Wait, how much are we talking?
What do you mean?
Quantity. In the basement, how big is this grow?
It wasn't very big. It's hard to talk about THC because the gram terminology is very different than when we talk about methamphetamine or fentanyl. The count that we charged with the possession with intent was 1,000 to 2,500, which, you know, if that were meth, that'd be a crazy amount. For THC, it's really not.
And so if I'm recalling correctly, there was, I believe, under 25 plants.
Well under, yes.
Well under, okay. All right.
Yeah, I think we found total 13.
13, okay, so that is well under. So, Ms. Stewart, I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
I do, Your Honor.
Did your attorney go over this document with you?
Yes.
Did she thoroughly go over it with you, essentially reading it to you word for word?
Yes, she did, Your Honor.
And you understood everything completely?
Yes.
Is that your signature on the second page?
It is, Your Honor.
It indicates you are pleading guilty to count 2, manufacturing and delivering THC greater than 200 but less than 1,000 grams. And Ms. Campion, is this as a party to a crime or does it matter? It was charged as party to a crime.
I mean, I suppose then she's pleading to the count as charged. So
Count
yes.
as charged. Okay, so you are 35 years old and you have 12 years of schooling. You can read, write, you understand the English language, no drugs, alcohol, or medications in the last 24 hours, and no mental illnesses or disorders. Is that correct?
Correct, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes.
Did your attorney go over with you the maximum possible penalties you face?
She did, Your Honor.
You are charged with crimes, and each of these crimes is listed on the first page of this plea questionnaire. From all accounts, you don't have a criminal history, correct?
Correct.
So this is your first experience in a criminal court, correct?
Yes.
Did Ms. Campion thoroughly go over your constitutional rights with you?
Yes, Your Honor.
Because this is your first experience, I want to make sure that you fully understand them. Do you need me to go over those with you in any more detail?
No, Your Honor.
So you understand them completely, and do you understand that by pleading guilty, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that pleading to a felony, as such, you will no longer be able to use or possess a firearm for life?
Yes, Your Honor.
You will no longer be able to vote in any election until your civil rights are restored.
Yes, Your Honor.
Do you understand what that means?
Yes, Your Honor.
Okay, so I don't need to go over that with you in any more detail.
No.
Now here, do you understand the state would have to prove as to count 2, which would be manufacturing THC tetrahydrocannabinols greater than 200 but less than 1,000 grams as a party to a crime, that on or around May 26, 2025 in Burnett County, Wisconsin, as a party to a crime, you manufactured a controlled substance, to wit, tetrahydrocannabinols, or THC, marijuana, in an amount of more than 200 grams, but not more than 1,000 grams, or more than 4 plants containing the THC, but not more than 20 plants containing the THC. That's a lot there. Do you understand all that I have just stated of what the state would have to prove?
Yes, Your Honor.
Do you understand what it means to be a party to a crime?
Yes, Your Honor.
Well, it means you either directly committed the crime yourself, you aided and abetted someone who was committing the crime, or you conspired with one or more people to commit a crime and one or more affirmative steps were taken towards the commission of the crime. So do you understand what it means to be a party to a crime?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of not more than 6 years or both?
Yes, Your Honor.
Do you also understand that there is an agreement that's been reached, and it was stated on the record, plead to count 2, that felony, have the other counts dismissed and read in for purposes of sentencing, and a recommendation of probation with a withheld sentence? Do you understand that offer and the agreement that you've reached?
Yes, Your Honor.
Do you understand that I'm not bound to follow that offer?
Yes.
And that means that I could, in my discretion, after looking at the facts of the case and hearing arguments, sentence you to the maximum possible penalty if I think it is warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes.
Did you go over the criminal complaint with your attorney? And in particular, if you look at that document, there's a section, it's called the probable cause section, where it basically says what happened that day and why you were charged with the crime.
Yes, Your Honor.
Yeah, and it looks like your attorney's showing you the electronic version right now.
Yep.
For the most part, as it relates to count 2 that you are pleading guilty to, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty to this charge because you are guilty?
Yes, Your Honor.
Did you maintain or did you manufacture at least THC greater than 200 but less than 1,000 grams?
Yes, Your Honor.
Ms. Campion, may the court use the probable cause section of the criminal complaint along with the statements made by your client to find a factual basis?
Yes.
Has anyone made any threats or promises to you, Ms. Stewart, for you to plead guilty today?
No.
You're doing so freely and intelligently. That means you are telling the court that you fully understand what you're doing.
Yes.
And voluntarily.
Yes, Your Honor.
Has your attorney represented you competently?
Yes.
Has she answered all of your questions?
Yes, she has.
Has she looked at this matter thoroughly?
Yes, Your Honor.
Has she discussed with you the discovery and evidence that exists in this case?
Yes, Your Honor.
Has she discussed with you any potential defenses or a lack of defenses in this case?
Yes, Your Honor.
Did she discuss with you what it would mean if you were to go to trial?
Yes.
Did she tell you it is your decision and your decision only?
Yes, Your Honor.
Are you satisfied with her services?
Yes.
Any questions for this court or for your attorney before I proceed?
No.
As to count 2, manufacturing or delivering THC greater than 200 but less than 1,000 grams, a class H felony as a party to a crime, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count 2. The remaining charges will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. Argument and sentencing recommendation, Mr. Schmidt.
Thank you. I already alluded to much of my argument in the statement on the public interest. The reason why the state really wanted to stick to the manufacturer count is mainly for 2 reasons. One, the manufacturer count actually doesn't care if it's intended for ultimate distribution. That is, if you're growing for yourself or creating a substance for yourself, it still violates the statute. It has ever since the legislature removed the exclusion for growing for personal use in 1993. So I think this is a statement everyone can agree happened. There's definitely this grow operation in the basement. There is some circumstantial evidence, as I outlined in the statement on the public interest, that perhaps some sale happened at some point, maybe in Burnett County. But to the extent of that, would be largely speculation on my part. The main driving force for why we still sought the conviction on this, even with those factors, and the fact that, quite frankly, you can just buy the substance legally if you drive 40 miles west, or you could buy something 20 miles east that is very similar to this with a similar effect legally, is because this case, as I said, did not come to our attention through the normal police channels. A child was at school who smelled of marijuana. The fact that a child is in this home and could be exposed to that is more concern. THC, the effects on adults are very different than the THC, the effects on young children. It can have longer term consequences. We really want to minimize that. That is the main driving force for why we are seeking this disposition on this case. And we'd ask the court to follow the same. Thank you.
All right, thank you. Ms. Campion.
Thank you, Your Honor. I echo the state's request for the court to follow the joint recommendation in this matter. I think it's been alluded to already. Ms. Stewart has no prior criminal history. And I think that that is a good basis to accept the plea just on its face, and that, you know, I think she's had a history in her life of being law abiding. She and her husband live on a home that I would describe as like a somewhat urban rural homestead. They produce a lot of their own food. They have bees, they grow herbs, they have a garden. They run a variety of businesses out of their home, including upholstery. I think they were renovating at the time of this incident, a trailer to run a business out of the trailer. They both have multiple jobs, multiple income streams, and they do have people occasionally coming into their home to buy products. But I say that to kind of describe them as kind of like, you know, like a Renaissance couple. They like to do a lot of things for themselves. Unfortunately, in this case, that also includes growing marijuana. And that's what Ms. Stewart has admitted to today and is pleading guilty to today. The court was correct in the number of plants that were found in the home. I would describe it as a limited amount. Law enforcement also took some product that was frozen out of a deep freezer in the garage. Some of it tested positive for marijuana. Other product that initially was believed to be marijuana was actually mint. Like I said, they grow a lot of product in bulk. The state is correct that the case came to them not because, you know, these two were on their radar for, you know, dealing drugs in this community, but because law enforcement came to find out that a student at the high school smelled of marijuana. After the investigation began, CPS was contacted, which makes perfect sense. And after an investigation, it was determined that she was safe to remain in the home. I don't think there was ever concern presented that this individual, that their daughter used marijuana. So I do think that that is an important factor in considering what the outcome is here today. So when we think about the gravity of the offense, I do think it is limited to this couple, this family. I understand the state's description of the circumstantial evidence in this case. As I alluded to previously, they have several businesses that they run out of the house. I think the ledger that was found related to the upholstery business, not the sale of marijuana. The instance of the potential alleged sale that was described by the daughter, I don't think that she saw marijuana exchanged. I don't think that was the description that was made. So certainly, I think there's very, very limited evidence, if any at all, that this left the home. So really, it was in the home, and it was limited to Mr. and Miss Stewart, not their daughter. So it's product being used internally. That said, there is still obviously a concern for the protection of the public and certainly a protection for their daughter. I think that that's addressed in line with the rehabilitative needs here, which is to say that they don't grow that product anymore. Their daughter is a freshman in high school. She'll be in the home for at least another 3 years. Obviously it's not legal to own and possess in Wisconsin. So indefinitely that's the solution, but certainly something that the court would want to take into consideration while their daughter is still in the home. I think that this agreement allows for that supervision for that time, which I believe is appropriate here. Additional rehabilitative needs outside of just not having that product. I think certainly an AODA assessment is useful to ensure that any treatment needs are addressed. I don't believe there are any additional needs. Ms. Stewart works. She's a mother. She's provides for her family. I don't think that either party has identified additional needs. I think that taking accountability today, having the felony on her record is certainly extraordinarily serious. Having no criminal history prior, it will impact her for the rest of her life. That alone, I think, is a significant punishment here. And so I think that that is sufficient and does not require the need for jail. Certainly it's available if she violates probation, but I think that giving her the benefit of probation to begin with is appropriate here. 18 months, in my mind, is a sufficient amount of time to address the seriousness of the offense without, dragging it out for an unnecessary period of time that ultimately could just waste taxpayer dollars that we don't need to do, but allows for an extended amount of supervision to ensure, that Ms. Stewart remains law-abiding moving forward.
Thank you, Ms. Campion. Ms. Stewart, I'm now going to give you an opportunity if you wish to. You don't have to, but if you wish to make any statement, let me know anything that you want me to know. If you've heard something you want to correct, or if you've heard something you want to expand upon, you will have the floor if you wish. Again, you do not have to.
No, thank you, Your Honor.
Okay, thank you. Ms. Stewart, in sentencing an individual, a court has to do certain things. First, I have to look at the nature and the gravity of the offense. How serious is this matter, okay? Then I have to look at you and your character, any past criminal record, your age, your education, a whole bunch of things about you. If you have any specific needs, mental health, AODA, those types of things. And then thirdly, I have to look at needing to protect the public. Here, we're dealing with a substance, an illegal substance, THC. And as Mr. Schmidt argued, you can go in any direction pretty much out of the state of Wisconsin, and you can get THC legally. Not here, not ever. And I don't see it in the near future, but I'm not the legislature. Okay, they get to decide. The issue with this case is because the issue is the growing, having that grow operation of the THC. There's not concrete information that it rises to a higher or more serious level because there may be some sales, but there's no way to determine whether or not that's accurate or true or what that even meant. And with the small amount of plants, this isn't a tremendous grow operation. It's not under a huge, the whole basement. We've had grow operations in this county before, acres. Okay, this is not an acreage issue. This is 13 plants or they're around. I don't know why or the reasons that you have or your husband has or anything about why you smoke THC. Again, it's illegal in Wisconsin, any way, shape, or form. Own, possess, sell, whatever. But I'll leave those things to you and to a probation agent to determine. The other area here that raises the seriousness is the fact that it involved your daughter. And that's what I look at the most here, is because a juvenile who now isn't a freshman in high school, but was 8th grade at the time of this incident, it put her in a very difficult position. I don't know you. I don't know your husband. I'm going to guess that it's your daughter together, but I don't know that either. But it's putting her in an extremely awkward position. because you're her parents. She loves you. She respects you. She wants to protect you, even though you're to protect her. But then she goes to school and it's inevitable that it's found. And I'm sure there's a lot going on internally with her. Hopefully that's going to be addressed, and hopefully she knows that her mama and her daddy are not upset with her, that she did the right thing. Because again, she was put in that position. She doesn't need to carry the burden that the adults have. She needs to be a kid and experience still being a kid, because a freshman in high school is still a kid, still a very young girl who has her whole life in front of her. And we don't want to make it any more difficult than it already is. High school sucks. And I'm sure it's even worse now with all of this technology. So this it edges towards seriousness. And I do have to look at the protecting of the public. I have to look at, now, is this something that I have to deter others from doing? Do I have to look at, am I going to be needing to deter you from doing this again or doing something similar or any other crime? You are an adult woman of an age where you do not have a criminal history of any kind. And I'm going to tell you, you can probably sneeze in one of these counties and get a disorderly conduct. Okay. So the fact that you don't have any type of criminal matters in your background says a lot about you. And hopefully that this is going to be the time that you're going to make the change and you're going to do the things. And you're just going to make sure that, sometimes parents don't always do the right thing. We don't. But hopefully you're going to be better at not showing your daughter those types of things. I think probation is appropriate. 18 months of probation is not going to be fun at all. You're going to have to check in with an agent. You're going to have to do some drug testing and all those types of things. And hopefully it's not going to get any further. 18 months of probation, I will follow that recommendation. I'm even going to follow the recommendation for a withheld sentence. Now, I never think, I'm going to tell you right now, and I'm going to say it on the record, this is never going to be a prison sentence unless, let's say that maybe you were found again with a grow operation and then it's bigger and all those things and you don't learn your lesson. But looking at the facts here, this is not a prison case. The fact that you are now a convicted felon, where this is going to remain on your record forever, that's a punishment. That's a punishment alone. And to have the probation and all of those requirements that you're going to have to do and you're going to have to complete, that's a punishment. And I think having those punishments and penalties on you, I think they are going to hit you hard, and I think they are hitting you hard. You're just better at putting on a brave face and being strong. I don't foresee revocation in this matter, so I don't believe I will need to make any determination upon any type of incarceration sentence. And that's why I'm not doing an impose and stay, because I can't say with this case how much jail, at least at this time, it could be. I don't think I'm going to have to worry about that. I think you're going to do all that you need to do to stay on the straight and narrow. I am going to assess $500 in fines and fees and court costs and surcharges. I'm waiving $18. I'm not going to make you come up with the other 18. You already have $500 posted. Conditions of probation, absolute sobriety. That means no alcohol. That means no illegal substances. Regular testing of both alcohol and or illegal substances. I don't necessarily know or believe that you may need an AODA assessment, but it's not, it won't harm anything to go through that and to do that. So I will order the AODA assessment. I don't see many other conditions here. Just stay out of trouble so you're not going to be back in front of the court. And you are working?
Yes.
Where do you work?
I own my own cleaning business and I also work at the Pheasant Inn in
Okay.
town.
All right, so I'm not gonna put on a no bar, no establishment that serves alcohol. I don't think alcohol is your issue, honestly. I'm not saying that you have a issue, or I'm not defining you as having an issue. But with this case, there was an issue that needs to be corrected. I do need your DNA. You're gonna need to provide that to the jail. You'll come up here and get a form when we're done. Go to the jail, provide your DNA. You have the ability to request it be expunged through a written letter to the Department of Justice, not to me, to the Department of Justice. It's really easy to do. You can Google it or ask Ms. Campion. I'm sure she can explain it to you. This, I believe, would be able to be expunged. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. Again, felony, no use or possession of a firearm for life, no voting in any election until your civil rights are restored. Mr. Schmidt, what am I missing?
Nothing from me.
Did you stay overnight, Jim? Did you get up next?
2 days
Or
of jail
arrested?
credit. She was, yep. So I believe 2 days of credit.
Okay, 2 days of jail credit if you are revoked. Oh, I bet that was a lesson in and of itself as well. Even
Yes,
though we
Your
have a
Honor.
beautiful new jail. I hear it's, well, I've seen it. It's beautiful. 2 days of jail credit. Anything else I'm missing, Ms. Campion?
I don't believe so, no. Does she need to report today?
For the DNA, yes.
No, I apologize. For probation.
Oh, for probation. Yes, that too. And you're still in Lynchbridge Road,
Yes.
2314, last four of your cell? 23.
Oh, that
14?
says mine is 030.
Is at it. All right, so report to probation as soon as you're done providing your DNA. Just go over there, they'll get everything started and they'll get you going, okay?
Okay.
So come get the documents from the clerk and then you are on your way.
Thank you, Your Honor.
Mr. Stewart. We will go on the record in the matter 25 CF 37, State of Wisconsin versus Jared Stewart. The state appears through District Attorney Kevin Schmidt in person. Mr. Stewart appears in person with his counsel. And you're Mr. Graham?
Correct, Your Honor.
Zachary Graham. We're set today in this matter for a plea and sentencing. The parties have reached an agreement. Mr. Graham, please recite it for the record.
Thank you, Your Honor. The agreement would call for Mr. Stewart to plead guilty to count 5, manufacture THC under a deferred judgment of conviction for 3 years. He would also plead guilty to a misdemeanor count of possessing THC, getting convicted on that misdemeanor count. Withheld sentence with or without the PSI, pay costs, and then probation being that he have no use or possession of non-prescribed controlled substances, do an AODA evaluation, follow the regs, and then counts 4 and 6 would be dismissed and read in.
Why the difference in the agreements?
Originally, I sent an offer where it would be the same for both of them. When they contacted me back, he has actual job consequences where the conviction on that one count would be extremely negative for him and harm the family household. I responded back, so long as one of them was actually convicted of it, I'd be fine with the DGOC on the other, especially since there'd be supervision in the home. And my mind was, I really was more concerned about protecting the child than the other things, given the circumstances I already described in the public interest and sentencing argument in the other case.
Am I remembering correctly that you have military background?
Yes, I'm the National Guard, Your Honor.
Okay, so then that would be the impact. And Mr. Graham, you thoroughly researched the conviction of a misdemeanor of the same?
We have, Your Honor. There's a potential that the federal government will determine him as an unlawful user of a controlled substance, and then he would have potential firearm ramifications. The plea here doesn't involve using. In my experience, that typically will sometimes bar you from purchasing a new firearm, but it's not going to do anything to affect your current firearm rights. So given that, I think this is the safest way while still taking accountability to, address this case in an appropriate way and also hopefully protect his guard service moving forward.
How long have you been married?
It's 11 years, remember correctly.
Ms. Stewart, how long have you been married?
12 years, 12
12
years.
All right. And, I usually, I don't delve into the personal aspects of these kinds of things, but I get protecting the family unit, and in the end, it's protecting your young daughter who is, well, you heard what I talked to your wife about, but you both thoroughly talked about this and you're okay with it?
Sure.
Okay. I understand the ramifications of employment. And I understand needing to provide for your family. Are you the breadwinner?
Yeah, I'd submit that they both contribute to
Oh,
financially supporting the household.
both pretty dual.
Yes.
Okay. We're just worried about how this is going to impact your ability to be in the guards.
Yes, Your Honor.
Okay. All right. Plea questionnaire, waiver of rights form, deferred judgment of conviction.
Yes, Your Honor.
Should you bring them up? Thank you. So I do have in front of me both of these documents, Mr. Stewart. Did your attorney thoroughly go over these documents with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Is that your signature on the second page of both documents?
Yes, Your Honor.
Formal motion to amend. I don't know which count you're amending, count 1 or count 4? Or you're adding?
Yeah, it'd have to
count?
be count 4 because the DJOC is on count
5.
5. Yeah.
So amending count 4 to possession of THC simple.
So made.
Granted. So you are pleading guilty to 2 counts here, Mr. Stewart. 1 count of possession of THC tetrahydrocannabinols simple. That means as a misdemeanor without anything else. And you're pleading guilty to the manufacturing, delivering THC greater than 200 but less than 1,000 grams as a party to a crime. Is that correct?
Yes, Your Honor.
You're 49 years old. You have 12 years of schooling. You can read, write. You understand the English language. No drugs, alcohol, or medications within the last 24 hours. No mental illnesses or disorders.
Yes, Your Honor.
Did your attorney thoroughly go over with you what the state would have to prove your guilt beyond a reasonable doubt?
Yes, Your Honor.
Did your attorney go over with you the maximum possible penalties you face?
Yes, Your Honor.
Because you're charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on the first page of both of those documents. Did your attorney thoroughly go over those rights with you?
Yes, Your Honor.
Do you understand them completely?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty to these counts, you're waiving and giving up those rights?
Yes, Your Honor.
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand that you are pleading guilty to 1 felony count, but the court is being asked to have that as a deferred judgment of conviction? Do you understand that if I accept the deferred judgment of conviction, this won't come into play? The no use or possession of a firearm for life and no voting in any election until your civil rights are restored.
Yes, Your Honor.
But you understand that if at any time the court enters judgment, revokes this document, this deferred judgment of conviction, and that means you will be convicted, it will be entered, and you will be sentenced on the felony. Do you understand at that time you may no longer use or possess a firearm?
Yes, Your Honor.
You understand that if you currently do use or possess firearms, another ramification on the family unit is that they must be locked with you only possessing the key and knowing where that is. Do you understand that?
Yes, Your Honor.
Do you understand that here the state would have to prove on or around February 26, 2025, you possessed a substance, the substance was a controlled substance that contains THC, and that you knew or believed that substance was a controlled substance containing THC? Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a $5,000 fine or up to 6 months of incarceration or both?
Yes, Your Honor.
Do you understand that as it relates to count 5, manufacturing THC greater than 200 grams but less than 1,000 grams as a party to a crime, the state would have to prove on or around February 26, 2025 in Burnett County, Wisconsin, as a party to a crime, you manufactured a controlled substance, to wit, tetrahydrocannabinols, in an amount of more than 200 grams, but not more than 1,000 grams, or more than 4 plants containing the THC, but not more than 20 plants containing THC. Do you understand what the state would have to prove?
Yes, Your Honor.
Do you understand the maximum possible penalty could be a fine of up to $10,000 or imprisonment of up to 6 years or both?
Yes, Your Honor.
Do you understand that with that charge, it is a party to a crime? Do you understand what that means?
Yes, Your Honor.
Do you understand it? It means either you directly committed the crime yourself, you aided and abetted the person who is committing the crime, or you conspired with one or more people to commit the crime and affirmative steps were taken towards the commission of that crime. Do you understand what party to a crime means?
Yes, Your Honor.
Do you understand that there is an agreement that's been recited on the record? But do you understand I'm not bound to follow that?
Yes, Your Honor.
Said differently, I could sentence you all the way up to the maximum possible penalty for the THC charge, and I do not have to accept that deferred judgment of conviction. Do you understand that?
Yes, Your Honor.
And I could sentence you to the maximum penalties. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter guilty pleas?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney? In particular, that section called the probable cause section, where it basically says what happened around that time and why you were charged with the crime?
Yes, Your Honor.
For the most part, are those facts accurate?
Yes, Your Honor.
Are you pleading guilty today to possession of THC because you are guilty?
Yes, Your Honor.
Are you pleading guilty to manufacturing THC greater than 200 but less than 1,000 grams because you are guilty?
Yes, Your Honor.
May the court use the probable cause section of the criminal complaint along with the statements made by your client basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you, Mr. Stewart, for you to plead guilty to these charges?
No, Your Honor.
You're doing so freely and intelligently, telling the court you fully understand what you're doing
Yes, Your Honor.
and voluntarily?
Yes, Your Honor.
Has your attorney represented